You did. It's down. Both of them. I had it up earlier. Got the one on the right hand side is. Oh. Yeah. Turn that one down. There you go. Okay. Yeah.
All right. Let's go ahead and who do we have online waiting for the remote hearings?
We have Norma Rodriguez.
Let's go ahead and let Ms. Rodriguez in.
Okay, she should be in.
This is Pasco Municipal Court. Today is July 30th, 2021. We have several remote hearings scheduled this morning. Ms. Rodriguez, are you present? Your microphone is muted if you are.
I am, Your Honor. I'm trying to start my video, but it won't allow me. Good morning. Can you hear me, Your Honor?
Ms. Rodriguez, are you able to hear me?
I am.
All right, thank you. We are here today on several matters. There is something that's causing some feedback. All right. Which case are you prepared on, Ms. Rodriguez?
I believe I have Refugio Ramirez on, Your Honor.
I have that matter.
Did you allow him in the meeting?
Can you allow Mr. Ramirez in, please?
Wonder if it's muddy soil here.
Is he in your conference room?
He might be, Your Honor. That looks like my conference room.
All right. Mr. Ramirez, are you able to hear us?
Señor Ramírez, ¿nos puede escuchar?
Oh, I think your audio in your conference room is not connecting yet, Ms. Rodriguez. Well, it appears we have neither Ms. Rodriguez or have been able to connect to Mr. Ramirez. So while Ms. Rodriguez attempts to figure out why there's no connection at her end, we will take some of these in custody cases. Are there any interpreter in custody cases?
No.
we'll start with Dennis Odom. Stand where you are, please. Sir, you're here today on a charge of harassment, domestic violence. You having some issues?
Yes, sir.
That is a gross misdemeanor. If convicted, you face up to 364 days in jail and a $5,000 fine. There is no mandatory minimum sentence. However, a conviction would result in the loss of your right to possess, own, or control a firearm. Do you understand that?
Yes.
For the record, I have reviewed the affidavit of probable cause, and I do find probable cause. You do have a number of constitutional rights. Those rights were played before court started. Were you able to hear and understand those rights? You have had a chance to talk to the provisional attorney today, and after doing so, you've handed forward a statement of defendant on plea of guilty. There are no signatures on this form at all, counsel. There's no initials, there's no signature.
Yes, Your Honor.
Just a moment. Mr. Odom, I did return to you this statement of defendant on plea of guilty. I see there are some initials on this document under paragraphs 5 and paragraphs 10, indicating that you understand the rights you have and you understand the potential consequences for pleading guilty today. Is that correct?
Yes, Your Honor.
There's a signature on this statement as well. Did you sign this statement of defendant on plea of guilty?
Yes, Your Honor.
Did you do that to indicate that you have had enough time to talk to Mr. Huey about this case today, and you're entering this plea today voluntarily?
Yes, Your Honor.
With regard to this statement of defendant on plea of guilty, did you read this, or did Mr. Huey read it to you?
You read it to me?
Thank you. There's a recommendation contained in paragraph 6. You understand I'm not required to follow that recommendation. If you plead guilty today, you do face up to the maximum penalty. Do you understand that?
Yes, Your Honor. I won't follow the recommendation.
Other than this recommendation, has anybody made any promises or threats to get you to plead guilty today? To the charge of harassment, domestic violence, a crime which was committed on or about July 27th, 2021 in the city of Pasco. How do you plead, sir? Guilty or not guilty?
Guilty, sir.
Actually, that's July 29th, excuse me. Your statement is by way of an Alford plea. That means you've reviewed the police reports with the provisional attorney, and you, although don't believe you're guilty yourself, you do believe that if a jury were to hear these facts, they could find beyond a reasonable doubt that you committed this offense. Is that a correct statement?
Yes, Your Honor.
I will incorporate the affidavit of probable cause to find sufficient facts to support a plea of guilty today. I am signing the notice of ineligibility to possess a firearm. You must immediately surrender all firearms and any concealed pistol license. You may not possess, own, or have under your control a firearm. And under federal law, any firearm or ammunition or a concealed pistol license until your right is restored. Do you understand that, sir?
Yes, Your Honor.
You do have a right to address the court, Mr. Odom, before any sentence is imposed. Is there anything you would like to say?
Yes, Your Honor. I'm sorry. I made a poor decision last night, and I know the recommendation has some jail time, sir, but I just recently started a new job, and I don't want to lose this new job. And if there's any way I can do like something, I don't know, something else other than a day in jail, I mean, I would really appreciate it, but you're gonna make the decision, sir, and I thank you, and I'm sorry about my poor decision.
Were you scheduled to work today?
Yes, I am, sir. I'll be there at 3 o'clock, and I don't know I'll be out here by then. I mean,
It's been more than 2 years, Mr. Odom, since you had any trouble.
yes, sir.
What happened?
I made a really poor decision last night. I was just, it was me and my brother-in-law, we kind of got into a little disagreement, and which led to this.
All right, you indicated, Mr. Odom, that you are working. What kind of work are you doing?
It's fast food, but it's Sonic Drive-In,
All right. Is that full-time or part-time?
full-time, sir.
Do you support anybody besides yourself?
My daughter,
Are they paying you minimum wage right now?
it's a little higher than minimum wage, like 14.80 or something like that.
Is there any other income to your household?
No, sir.
I'm going to find that you meet the statutory definition of indigence. I'm not going to impose any fines or costs. 364 days in jail with 363 days suspended, credit for 1 day already served. You will be on probation for 2 years. During that time, you're not to have any criminal violations. You're not to have any domestic violence related incidents. You are to report to probation and follow their recommendation and have a risk assessment within the next 60 days. Do you understand that?
Yes, Your Honor. And the question is that probation department, is that here?
Yes, it is.
Yes, sir.
Remind you, you have lost the right to possess, own, or control a firearm.
I don't like those anyway.
Mr. Odom, the address I have is on Deschutes. Is that still current?
Yes.
All right, your first appointment with probation is on August 24th at 1:30 in the afternoon. It's a telephonic appointment. You must keep that appointment. A failure to do so would result in a warrant being issued for your arrest. Do you understand that, sir?
Yes, sir.
All right.
May I ask you a question, sir? So when will I be released?
You'll be released as soon as they can process you out.
Okay, yes, sir. Sorry, I may get some work. Thank you, Your Honor.
All right. Stay out of trouble.
Yes, sir.
All right. Did we lose Ms. Rodriguez?
Looks like she's in the waiting room.
So,
Get her back in.
yeah, let her back in. Case. All right, we are back in contact with Ms. Rodriguez. Just for the record, Ms. Rodriguez is appearing remotely. Mr. Ramirez is appearing remotely. Mr. Ramirez, are you able to hear us?
Señor Ramírez, ¿puede escucharnos?
All right, thank you.
Gracias.
Ms. Rodriguez, what are we doing today?
I can actually take over, I guess, if we did receive the results of the 1077 evaluation. They did come back as not competent. So the city this time is going to be moving to dismiss without prejudice. I do have that paperwork here. It is lacking the defendant's signature. There's a firearm form as well. I just haven't been able to connect with Ms. Rodriguez to get the necessary signatures on that. And one note on that, Your Honor, it was recommended that he have a DCR evaluation prior to being released. However, I just see a text from Mr. Rio given this morning that indicates that he was seen by a crisis counselor from Lords, and he did not meet the criteria for to be evaluated under the health crisis services. So it looks like they won't take him. So I guess the DCR evaluation is no longer necessary, as it has already been held.
Ms. Rodriguez, is there anything you'd like to add to that?
Unfortunately, there was quite an echo there, but I'm assuming that he said that you did receive the letter from Crisis Response. Is that correct?
Yes, and that he is requesting that Mr. Ramirez's right to possess a firearm be revoked as well. Ms. Rodriguez, I think your mic is muted again.
You need anything else from me, Your Honor? Are you signing those orders? It's just that the communication that I'm getting is really echoed.
I am signing the order dismissing. There is a request that Mr. Ramirez's right to possess a firearm be revoked.
I understood that, Your Honor, and that's fine.
All right.
No objection to that.
So I will sign that notice of ineligibility to possess a firearm. We'll forward these to you this afternoon. You can review those with your client. I must advise you as well that the Department of Licensing will be advised regarding this finding of incompetence as well. Okay. I've signed the orders.
Your Honor, does that affect his driving privilege? Do you know?
I believe that the department will suspend his license based on the finding that he's not competent and set a hearing to review that. So I think they'll be served with a notice that his license will be suspended and given an opportunity to address that based on this finding.
Okay, I have a question. I'm hearing you, and then I'm hearing the interpreter really faint, and I know that my client is in the conference room at my office. I just need to make sure that he heard, and I believe I do have a staff member in there. If my staff member can indicate as to whether they could hear the interpreter.
The interpreter sounded rather echoey.
I'll explain everything to my client, Your Honor, after we hang up then.
And I apologize for that, Ms. Rodriguez. We're in the middle of switching from Zoom to WebEx, and the account for WebEx has not been authorized yet, so we're still relying on the equipment that's joined together from both of those systems.
Not a problem, Your Honor. Thank you.
All right.
That concludes that matter. I believe I had another matter on Jill Adams.
Yes, Jill Adams.
That should be a dismissal after an SOC.
Yes, sorry, Your Honor. Yeah, that is correct. That I show paid in full, no criminal charges, is dismissed for compliance at this time.
Based on that record, I will dismiss those charges. All right, I think that concludes your cases, Ms. Rodriguez. Thank you.
It does, Your Honor. Thank you so much. Have a good day.
You as well. It's, and have you had communication with Mr. Phelps' office?
I have, Your Honor, that's gonna be a reset. We can call that really quickly if you'd like.
Let's go ahead and allow the attorney and Mr. Kasab in.
I don't see them. I see Mr.
No, I think we told them, we indicated they did not need to appear today. Here, it looks like Mr. Kasab is in the hospital, as Mr. Schmidt had asked for a reset on the case. Mr. Rio agreed to that. Mr. Schmidt agreed, as was Mr. Rio, to move it to August 27th at the defendant's request. I do have the emails if you'd like to see those. But Mr. Rio did neither him nor his client needed to appear.
Reset to August 27th, defendant's request without notice. How about Brian Ashbuck and Michael Jackson?
I am bringing them both in. Looks like they're both in.
All right. Good morning, gentlemen. We are here in Pasco Municipal Court. I want to apologize if you're having an echo in the audio. We're in the process of moving from Zoom to WebEx, and there's multiple devices connected that normally would not be. So, Mr. Ashbach, your microphone is muted, so we won't be able to hear any of your responses. If you could unmute yourself. Thank you.
Thank you, Your
Mr.
Honor.
Jackson, you as well. What are we doing here today, gentlemen?
Well, Your Honor, my hope was to be able to resolve this today. We're still working through some DOL issues, getting their records cleaned up. There are a couple things that prevent him from being relicensed, and they appear to be errors. One of the things on his ADR says he needs to have an HTO reinstatement hearing. We've already had that. That was found in his favor, but getting that removed from his ADR has been difficult. They also show that there's a financial responsibility issue that's holding up his license. We addressed that in the HTO hearing. That should be cleared up. So I'm trying not to swear, Your Honor. It's just been a huge mess dealing with departmental licensing and getting him relicensed.
So are you asking for some additional time?
I am, yes. That was the prelude to requesting more time, yeah.
Mr. Bell, what's the city's position?
City's okay with giving them some additional time.
How much time do you believe you're going to need, Mr. Ashbach?
Boy, to be honest, I would hope that this would have been able to be cleared up months ago. So I would just say a couple of months, please.
I'll defer the court, Your Honor.
September 24th?
Sure.
We'll reset on defendant's request to September 24th. That's without any written notice from the court.
Sure. Will that be allowed to be done via Zoom, Your Honor?
Yes.
All right, thank you.
It may be WebEx, I'm hoping by that time, so.
Okay, sounds good. I'm familiar with WebEx as well.
Yeah, all right. So you might want to just check in with the clerk's office before that date to confirm whether it's WebEx or Zoom. Okay.
I will. Thank you very
All
much.
right. Thank you,
Have a nice day.
gentlemen. Your excuse. I think that's our last.
Yep.
All right, we will turn back to our the folks who are in custody. Go next to Shauna Lance. Go ahead and stand up where you are, Ms. Lyons. You are here today on a charge of hindering a police officer. That is a gross misdemeanor. If convicted of that offense, you do face up to 364 days in jail and a $5,000 fine. There is no mandatory minimum sentence for such a conviction. Do you understand that?
Yes.
You do have a number of constitutional rights that were played before court started. Were you able to hear and understand those rights?
Yes.
Do you have any questions about those rights?
No.
You have had a chance to talk to Mr. Huey today about this case, and after doing so, you had forward this statement of defendant on plea of guilty. Have you reviewed this statement with Mr. Huey?
Yes.
When you did that, did you read it or did he read it to you? There are some initials under paragraphs 5 and paragraphs 10 indicating you understand your rights and you understand the potential consequences for pleading guilty today. Is that a correct statement?
Yes.
There's a signature on this statement of defendant on plea of guilty as well. Is this your signature?
Yes.
And did you sign this to indicate that you've had enough time to talk with Mr. Huey today and you're entering this plea today voluntarily?
Yes.
Now, I believe you're here because a warrant was issued for your failure to appear at a prior hearing. Ms. Chang had been appointed to represent you. You wish to go forward today and resolve this case without talking to Ms. Chang?
Yes.
You understand the recommendation that's made here today is just that. It's a recommendation. It's not binding on the court. If you plead guilty today, you do face up to the maximum penalty. Other than this recommendation, has anybody made any promises or threats to get you to plead guilty today? To the charge of hindering a crime which was committed on about November 3rd, 2019 in the city of Pasco, how do you plead, guilty or not guilty?
Guilty.
And your statement is by way of an Alford plea, which means you reviewed the facts with Mr. Huey and you understand and believe that if a jury were to hear these facts, they could find beyond a reasonable doubt that you committed the crime of hindering a police officer. Is that a correct statement?
Yes.
Will incorporate the affidavit of probable cause, find sufficient facts to support a plea of guilty. You do have a right to address the court before any sentence is imposed. Is there anything you'd like to say?
Thank you for your time.
Ms. Lyons, have any correct?
She has 1 day plus 1 prior, total of 2 days.
Thank you. Are you working, Ms. Lyons?
Not at the moment.
How are you supporting yourself?
What was that?
How do you support yourself?
My mom.
Pardon me?
My mom, right now.
When was the last time you worked?
It's been a couple of years just before my charges.
Why is that?
Because of, I guess,
Pardon me?
loss and the charges.
Do you have any physical disabilities that keep you from working?
No,
Do you support anybody besides yourself?
I should be supporting my children.
Pardon me?
I should be supporting my children.
I understand that. I'm asking you if you do support anybody besides yourself. No? going to follow the recommendation. I'll adjust the fines and costs slightly based on your current situation, but I do make a finding that you have a future ability to pay. 2 days in jail, no days suspended, credit for 2 days already served, a fine in the amount of $250, a jail assessment of $100, a warrant assessment of $100, and a $43 criminal conviction. So payments at $25 a month, those begin on August 30th. What's your current address?
If you do, I don't.
Thank you. You can have a seat. Milo O'Malley. Now, you're here today on a charge of simple assault, domestic violence. That is a gross misdemeanor. If convicted of that, you do face up to 364 days in jail and a $5,000 fine. There is no mandatory minimum sentence for such a conviction, but a conviction would result in the loss of your right to possess, own, or control a firearm unless your right is restored by a court of record. Do you understand that? You have a number of constitutional rights. Those rights were played before court started. Were you able to hear and understand those rights?
Yes, sir.
I have reviewed the affidavit of probable cause, and I do find probable cause. Reviewing your application to court-appointed counsel, after speaking with a provisional attorney, I will appoint an attorney to represent you. That attorney's name is Mr. Matt Rutt. There is a request, it looks like, for a no contact order. Conditions of release, Mr. Mel?
Yes, Your Honor, the victim did request a no contact order, so the city's just gonna ask that that be put in place. It does feel it's appropriate given the assault the alleged assault that occurred. Then given the lack of criminal history, city is gonna be okay with the PR with the no contact order in place. And that's just the standard DV conditions.
Mr. Hughes?
Yeah, sure, Honor. I advise that there's a high likelihood of a no contact order being ordered. The victim requested, her concern is this, and I told her I'd raise it to Your Honor. I think a little bit of it, the facts are in the probable cause statement. He has a 10-month-old daughter, and her mother is trying to gain custody of that. She believes, she hasn't seen the paperwork, that she's trying to gain custody of it or guardianship. And it's not because of her, it's because of her boyfriend that she's living with. The mother doesn't trust the boyfriend. So she's asking for some guidance, I guess. She doesn't have the objection to the no contact order, but her 10-month-old daughter is with her mother, and the mother is not allowing her to have her daughter. So she wants to go back there for the one purpose of getting her daughter.
Well, she's not going to be able to go back there herself. This order is not going to affect the child. It's not going to limit her ability to see the child, but given the nature of the charges, she's not going to be allowed to go back to that house.
She did say that she had put a temporary restraining order, and she filed for emergency guardianship over my daughter, but I haven't seen any papers.
I don't see anything filed either.
Yeah, so I don't know.
But that still doesn't affect, you're not go back to that house. Under the terms of this no contact order, do not cause, attempt, or threaten to cause any bodily injury to, assault, harass, stalk, or keep under surveillance the protected person. Do not contact the protected person directly, indirectly, in person, or through others by phone, mail, or electronic means, except for the mailing or service of process of court documents through a third party or contact by your attorney. Do not knowingly enter, remain, or come within 500 feet of the protected person's residence, school, workplace, or person. This is a pretrial no contact order. It will expire on July 30th, 2023. A violation of this order with actual notice of its terms is a criminal offense under the RCWs and will subject you to arrest. Only the courts can change this no contact order after written request to do so. You can be arrested even if the person protected by this order invites or allows you to violate the order's prohibitions. Do you understand each of those?
Yes, sir. I have a question.
Yes.
So all of my clothes and stuff would be over there. How would I get those so I can go back to state?
You're going to have to make arrangements through a third party. There are conditions on your release. I'm not going to require you to post bail, but you are to contact your attorney and maintain contact with your attorney every week or as directed by your attorney. You're not to have any criminal violations. You're not to have any domestic violence related incidents. You're to obey the no contact order. Your next court date is Monday, August 23. You must provide an address at that time. Do you understand that?
Yes. So you said there was nothing filed for a temporary guardianship?
I don't see anything in my system that shows that.
So essentially through the third party, go get
Pardon me?
essentially through the third party, I go get somebody else and enter the house.
Well, I can't tell you whether or not there's been something entered on any emergency basis. It's only hasn't been entered into the system. So if she has filed something and it hasn't been recorded yet because it's a temporary, I mean, that's something that's possible. So I can't really give you advice on how to proceed, but I would say the first thing you want to do is, since this appears that it's in Franklin County, you're going to want to check with Franklin County Superior Court and see if any actions have been started. Okay. Thank you. You can have a seat. Jacob Corbin. Corbin, you're here today on a charge of simple assault, domestic violence. That is a gross misdemeanor. If convicted, you do face up to 364 days in jail and a $5,000 fine. There is no mandatory minimum sentence, but a conviction would result in the loss of the right to possess, own, or control a firearm. Do you understand that?
Yes, Your Honor.
You have a number of constitutional rights that were played before court started. Were you able to hear and understand those rights?
No, Your
Honor, sorry to interrupt, but I think you've already gone through arraignment.
Oh, is this a?
Yeah. This is a
Oh, I see. Ms. Wright has been appointed.
Your Honor, just to let you know, I talked to him, and I'm not sure if I checked the box, but he does not want my assistance on this. Other provisional attorney wants to represent himself today.
All right. Well, the only issue to address today are conditions of release. It looks like you failed to appear as soon as you were released on this, and a warrant was issued. Bail is currently set in the amount of $750. Mr. Bell?
Your Honor, she's going to ask that remain in place. It's more than appropriate given that he has 6 active bench warrants out. all out of Monroe Municipal Court. Most of those bench warrants are for failure to transfer title, drug paraphernalia, trip permit, things of that nature. But given the active bench warrants, the fact that a bench warrant had to be issued in this case to get him in here, he does have a history of warrants being issued in most of his cases. So the city does feel that bail's more than appropriate here. It's just asking for the $750 to remain in place, and then just the standard DV conditions.
All right, Mr. Corbin, since you don't want the assistance of Mr. Huey, I'll give you a chance to address the court. But the minute you start talking about the facts of the case here, I'll stop you, and that'll end your opportunity to say anything. Understand that?
Yes.
What would you like to say about being released?
If it would be alright with you, I prefer a written, just because it's easier for me.
Go ahead, you can read it.
Or, I would just like to start with the fact that I'm sorry for this work, and the explanation is in the later.
Go ahead.
Alright, I, Jacob Nathaniel Corbin, swear that everything I have written stated is the whole truth, nothing but the truth, no lie whatsoever. Personal judge, in the report it says girlfriend. Identify the girl, the man who accused me of hurting him. I did not hurt nor I see my girlfriend.
All right, that's it, Mr. Corbin. I told you not to talk about the facts of this case, so it's done. You're finished.
I'm sorry.
Okay? You have an attorney to represent you. You need to talk to your attorney about this case. Mr. Corbin, looking at your history, the only time you come to court is when warrants are issued. There's nothing here that convinces me that you're going to come back to court. You were here on March 16th of this year.
Sorry,
you were released and you failed to return at the next hearing. So bail is appropriate. You have 6 outstanding warrants in another jurisdiction. In the cases in this case, in this jurisdiction, warrants were issued in those cases as well. We'll set this over. So bail's going to remain in the amount of $750.
Your Honor, could I possibly please move to the part of the letter which talks?
No, I told you if you talk about the facts of the case that you were finished. You're done. Would you be able to post that bail?
No, Your Honor.
Set this for Monday, August 16th.
Your Honor, could we possibly do next Monday, please?
No.
Would you be willing to read this letter?
No. Give it to your attorney.
May I speak one more time, please?
No, we're finished.
She's already appointed.
Is right. Jeremy Clark.
Afternoon, Your Honor.
Hello. Sir, you're here today on a charge of violation of other court order. That is a gross misdemeanor. If convicted of that, you can face up to 364 days in jail and a $5,000 fine. There is no mandatory minimum sentence for such a conviction. However, a conviction would result in the loss of your right to possess or own or control a firearm. Do you understand that, sir?
Yes, Your Honor.
You do have a number of constitutional rights. Those rights were played before court started. Were you able to hear and understand those rights?
Yes, Your Honor.
You did talk to the provisional attorney, and after doing so, have indicated you wish to plead not guilty and request the court appoint an attorney. I will appoint Ms. Chang to represent you in this case. Is Mr. Huey still here?
I was hoping you could help me.
Let me help you.
You have this way. Is your address still on North Hillcrest?
That's what I just updated to, yes, sir.
That's not a mailing address though, Connor. What's your mailing address?
It would be 421 P.O. Box, Connell, Washington. It's a real little town, it's got a little, you know, area.
All right, Mr. Bell, conditions of release here.
Yes, Your Honor, and I may have missed if you said it. I think he's being held on $1,000 bail. That's, I believe is what is in the document.
Yes, bail was set at $1,000 when it failed to appear to the arraignment.
Thank you, Your Honor. The city's going to ask if that remain in place. Feels that it's appropriate given one, that it took a warrant to get him here on this case. He also has 2 other pending violation of court orders. It looks like this occurred since his last court date of violation of court orders that he was here for, and so he's now continuing to commit new crimes, but he's violating the active no contact order, with this being now the 3rd violation, and so out of concern for the safety of the victim, and I guess if I recall correctly, just from the facts, that this was not a sort of mutual, where she was kind of in agreement, maybe wanted him there, but that he was kind of saying something to her that to the effect of, you better watch yourself, or something like that. So city has concerns for the safety of the victim, with him violating the court order. Again, since his last court hearing, warrants have been issued on at least one of the other court orders. City feels that bail remaining in place is appropriate. And then just the standard DV conditions.
Yeah, Your Honor, he does have some pending cases with, I think, Ms. Chang is the attorney.
Yes.
This particular case, unless I'm mistaken for another one, the reporting party is the mother of the protected party. The actual victim was not there, so they're saying the allegation is she's gone to the resident where the alleged victim lives, but the alleged victim was not there at the time. Probably, we're not objecting to probable cause, but it comes down to, in this particular case, he said, she said, the mother saying that he was there, and then by the time the police got there, he was gone. So this was served by way of summons. And I asked him, did he know about this court date on July the 20th? And he indicated no, he didn't receive anything. And I think it says it's mail. I gave him the address, the last DOL address, and he said he had lived at that location for quite some time. Right? So he is coming to court, I believe, on all those. To me, it's there's no corroborating evidence other than the mother saying he was there.
I'm not arguing the facts, or listening to an argument of the facts of the case today. That's not what we're here for.
I'm just saying, to me, they're kind of a little bit weaker. We're talking about kind of how severe the case is, or they're aggravating facts. I don't believe there are any aggravating facts, but he's 30 years of age. He's been in Tri-Cities his whole life. The only time he left is when he was in the military from 2009 to 2013. He's going through a tough time right now. He had a construction business, but because of all these arrests, he has lost his business. So he is hoping for PR, or at least he thinks he can post $500.
Your Honor, I just want to correct myself quickly. I realized I had clicked on one of his other no contact orders. This is, the facts of this case are sort of him appearing at her residence and not the restaurant, which was a different one. So I just wanted to clarify that.
At the time of the arraignment in July 20th of this case, Mr. Clark had several outstanding warrants for failing to appear in court on one of the other violations. Warrants had been issued, and I think he ended up having to post bail in that case. Mr. Clark, I take these violations of no contact orders very seriously. You should too, and particularly in considering whether or not I should release an individual. I look at both future appearance factors as well as the showing of substantial danger factors. The allegation that you continue to make contact after the order was put in place, and now this is number 3, causes me some concern. Bail is currently set in the amount of $1,000. It will remain there.
May I say one thing? I know I'm not supposed to, but if
Don't talk about the facts of the case.
obviously, yes, you know that. Just like to say, Your Honor, I'm the sole provider of 7 children. I'm doing all that I can for everyone that I can, and in no way, shape, or form, I'm supposed to be, innocent until proven guilty, and these are allegations. I do take them seriously, and I'm sure you do too. I ask that, due to the fact I've lost my company and have to support 7 children solely, I ask that you just maybe lower my bill to $500. I'm not asking for the PR today. I'm not asking for you to forgive me on matters that we don't know if are true. I'd just like to be the man that I am, and I can't be that here in this place, and the father that I am.
I think given the allegations, given the number of alleged violations of the no contact order, given the facts of the prior violation of the no contact order that does involve a threat or a cautionary statement made to the alleged victim, protected party, I think $1,000 is appropriate in this case. Looks like you have a court set on August 16th, so we will set this case over to August 16th with that matter as well. Christy Vanderpool.
Yeah, I think this one can go fairly fast. She indicates that she doesn't plan on bailing out.
And I would just say this to set the tone of the record here. These are on Ms. Vanderpool's cases. The bond company arrested her and revoked the bond, so they placed her back into custody. I think that bail was set in the amount of $2,500. Mr. Libert represents on this case.
Correct. She is just hoping to get, if you can quick set this to Monday, and she is hoping to maybe resolve the case with Mr.
Yeah,
Libert.
that's not going to happen.
That's not
We
gonna
won't. No, I won't set a case from Friday over to Monday. No.
happen. Okay, so
Mr. Libert's also gone on Monday, if I recall, and so it would probably get reset anyway.
So whatever is quickest, I guess.
The earliest I can set this right now is August 16th.
Okay, August 16th.
Your Honor, what happens if I go ahead and plead guilty without my attorney?
I'm not going to address that today. All other conditions of release remain the same. on cause number ending in 283, you're not to drive without license or insurance, you're not to possess or consume any alcohol, marijuana, or non-prescribed drugs. You have to submit to a test if you do post bail. On the theft charge, again, conditions of release remain the same. Bail is set in the amount of $1,000 cash or bond. Jeffrey Dent.
Yes, Your Honor, when you're ready, we do have an objection to probable cause only on the assault. There's 3 counts. No objection to probable cause.
Go ahead.
Your Honor, if I read the PC correctly, it indicates that there was a struggle over a phone, and that's the basis of the assault. And they interviewed the alleged victim, and she indicates that yes, it was a struggle over the phone. She believes that any injuries caused during that struggle was an accident. Elements of the crime of assault is the acts are intentional. There is some other facts in the case, but I think the officer stated specifically that was the basis of the assault, but there was other facts throwing at the phone. He threw a phone at her, but again, on that particular fact pattern, it doesn't say anything about how close the phone came to her or whether she was placed in imminent fear of being hit by the phone. So again, I don't believe there's probable cause on the throwing of the phone fact pattern. So that's the basis of our objection.
I am going to find probable cause, and this is why. He may not have intended to cause her injury during attempting to remove the phone from her, but he did intentionally attempt to take the telephone from her that resulted in injury to another individual. That's the way I read this affidavit of probable cause. So his intent was to forcefully take the phone because clearly she was not cooperating in that. So I do find probable cause for both simple assault and the destruction or removal of property and the interfering with report of a domestic violence in this case. Mr. Dent, each of these are gross misdemeanors punishable by up to 364 days in jail and a $5,000 fine. There is no mandatory minimum sentence. A conviction would result in the loss of the right to possess, own, or control a firearm until that right is restored. Do you understand that?
Yes.
I've had a chance to talk to Mr. Huey today, and after doing so, I've indicated you wish to plead not guilty. I will enter a plea of not guilty on your behalf. Conditions of release.
Yes, Your Honor. First, the victim did request a no contact order, so the city's going to echo that request, ask that it be put in place, feels that it is appropriate given the alleged violence here. Also, of some concern, I guess, is the alleged violence kind of the level that the defendant seemingly went to ensure that the police were not called, and as the victim was attempting to, he takes her phone, destroys it, is fighting over it. The city has some concerns for the safety of the victim, that this was not just a kind of a one-off, but it was seemingly continuing to ensure that police were not contacted. So city's concerns for her safety. And while acknowledging that he does have a very limited criminal history, and nothing really since for some time, but because of the concern for the safety of the victim, city's going to ask for some bail in about $500 cash or bond, as well as a no contact order. And with that, just the standard DV conditions.
Yeah, Your Honor. As far as the no contact order, if he will agree to not having contact with her, they are married for 3 years and they have a child in common. But he's been in the Tri-Cities his whole life. He's 33 years of age. He has friends and family he can go to.
We have one left.
We're hoping
No file.
that you don't require him bail. He has a good job as a union electrician. Is that what it is? Union electrician. So he does have jobs based on the union. But his last conviction was, 11 years ago. So we're hoping PR.
I am not going to require you to post bail in this case, Mr. Dent. I'm going to issue the no contact order, however, and require that you abide by those conditions. Under the terms of this order, do not cause, attempt, or threaten to cause any bodily injury to, assault, sexual assault, harass, stalk, or keep under surveillance a protected person. Do not contact the protected person directly, indirectly, in person, or through others by phone or mail or electronic means, except for the mailing or service of process of court documents through a third party or contact by your attorney. Do not knowingly enter, remain, or come within 500 feet of the person's protected person's residence, school, workplace, or person. This is a pretrial no contact order. It is temporary, will expire on July 30th, 2023. A violation of this order with actual notice of its terms is a criminal offense and will subject you to arrest. You can be arrested even if the protected person invites or allows you to violate the order. Only the court can change this order after a written request to do so. Do you understand that?
Yes, sir.
You're not to have any criminal violations. You're not to have any domestic violence related incidents. You're to obey the no contact order. Make all your court dates. The next court date is Tuesday, August 24th at 8:30 in the morning. Do you know the address of where you'll be staying?
Not 100% on that answer.
All right, so you need to provide that at the next hearing. Understand that?
Yes, I understand.
You retain an attorney. Part of the conditions of release are that you stay in touch with that attorney. Do you understand?
Yes.
All right.
Can I ask you one question?
Yes.
I mean, because I might be able to give you an address. What is the address that I can go to for the no contact?
Wherever she's residing.
Yeah, we have 2 primary residences, so.
I'm not
That's
listing
fine.
that.
Okay, sorry, that's why I didn't want to.
I'm not listing an address, just wherever she's
Okay.
residing, you can go.
Okay.
Zip code.
Thank you, Ron.
All right.
Adam Green?
Yeah, sure. If I may make a quick record.
Yes.
I tried to talk to Mr. Green about the case. He was not responsive every time I asked him a question. He just put his head down. I noticed that earlier the jail indicated that he was late to come to court because the jail said he was sick. But then he did come down later. I asked him how he was feeling. He says not good. And the only other information I can get from him is, do you have any mental health issues? He said yes. And other than that, I asked him questions about whether he understands his charge. He's not responsive.
We're here on two separate cases. Cause number ending in 875 is a shoplifting charge from March 10th, 2021. An arraignment was scheduled on March 23. Mr. Green failed to appear for that court hearing. Bail is set in that manner in the amount of $500 cash or bond. I do find probable cause in cause number ending in 650. There's a shoplifting charge alleged to have been committed on about July 29th, 2021. So I will find a probable cause. Mr. Green, you don't want to speak with Mr. Huey about these cases? Do you understand the charges against you? You don't understand that the allegations are that you took on two separate occasions, March 10th and July 29th, an item from a store without paying for them? You don't understand that? As a point, an attorney, I'll note that the affidavit of probable cause and the police report indicates that Mr. Green does not have a permanent address, so we'll appoint an attorney to represent him.
Attorney Wright?
We'll appoint Ms. Wright. Given Mr. Green's response that he did suffers from some mental health issues, I think it's appropriate that perhaps counsel speak to him and determine whether or not some evaluation is in order. On cause number ending in 875, bail is set at $500. I think that's going to be sufficient on these two cases. So I'll release him on the new charge. We'll set these over to August. You're here on the 9th, is that correct?
Yes, yeah.
August 9th. And can we make sure that we notify Ms. Rife about this appointment and that I want her to contact Mr. Green at the jail to determine whether or not on her assessment she believes a 1077 evaluation is appropriate. If she makes that determination,
perhaps we can communicate with you, Mr. Bell, and make arrangements to have that signed next week, if that's possible, okay?
Yes.
All right. That'll conclude our hearings today.
Head back.